Okay, hello class, and welcome to Criminal Law Week 3. I'm sorry I can't be there in person, so we're just going to have to deal with a recorded PowerPoint, theoretically, if the camera works throughout the duration of this. It's been cutting on and off on me. It took me about an hour to get this set up, so hopefully it stays clear with us. Want to address the discussion posts from last week. That's entirely my fault. I did not check, or rather, I didn't see those conflicting instructions. So, of course, you all will not be penalized for that because instructions for what you're supposed to do should be clear. And it wasn't in that regard. So I went back and I adjusted all of the grades, and they should all be fixed now to reflect only having to have done one reply post. So if there are any questions about that whatsoever, or if you think your grade doesn't accurately reflect the requirements, feel free to email me. I'm happy to take another look at it or discuss it with you and see what the issue is and see if it is indeed an issue or not. So that brings us to chapter 3 and week 3, which is mens rea. And I'm not going to lie to you guys, this is not an easy chapter or an easy concept to grasp. It takes a lot of reading through it, maybe reading it a couple times to really understand what mens rea is and how the courts apply it, because they don't, as I'm sure you guys saw in the readings, they don't apply it in a completely consistent manner. It's a little bit tricky to wrap your head around at first, so I totally get that. If after you watch this lecture, hopefully you do watch this lecture, if you have any questions at all, feel free to email me. I know I don't have clear office hours on the syllabus, but I'm sure if you email me, I can find a time to come meet you on campus, whether that be in the library or somewhere, and see if I can help you out with any questions you may have. So with that being said, we move forward here and start with the purpose of mens rea. The prosecution has to prove beyond a reasonable doubt the mens rea elements of the crime. Just like with any element of a crime, they have to prove it beyond a reasonable doubt. So, with a theft charge, they have to show beyond a reasonable doubt that a person intended to deprive somebody of that property. If I take one of y'all's phones during class and I intend to keep it, I take it from you, obviously purposefully, and because I want to acquire that property and make it mine, that's theft. Is it theft if I accidentally pick up your phone because it looks just like mine and I put it in my briefcase and I walk out the classroom, get my truck, and leave? No, that's not theft. I didn't have the requisite mens rea to permanently acquire your property. And the reason that we have that is if there's no level of criminal intent, which is what mens rea is, then punishment is not appropriate. I shouldn't be punished for accidentally taking your phone, and vice versa. If one of you were to accidentally take my phone, you should not be punished for that. As it applies to us, of course, you should not be punished for the discussion post because you guys didn't have the requisite mens rea or criminal intent to not do the second reply post. Okay, it was a mistake, which we will get to later on. Going forward, just to give a brief overview, there are 4 levels of mens rea, and you'll see as we go on through the rest of the chapter that they go in order. Purpose, that is obviously the most intense one. To do something on purpose, to completely know that what you're doing is going to cause something. That one is obviously the most clear, and we'll get into some examples of that shortly. Knowledge, that is the second level of criminal intent there. Now, you might not be purposefully doing something, but you're pretty well aware what's going to happen with your conduct. You have knowledge of it. You are knowingly doing something, knowing that it very well might cause a criminal result. Recklessness, that is a little bit lower. That is basically a blatant disregard for serious consequences, or a blatant disregard of what could very well happen. And so blatant that it's outside the norm of societal standards. That's what you think of when you see reckless. That person's driving 80 miles an hour through a school parking lot. Reckless, of course, right? And then the last one, criminal negligence. That is a little bit lower than reckless, and we will get to an example of that later on in the lecture. Now, why do we have those different levels of mens rea? That's something that we're going to get towards later too. And the basic premise is that we don't want to punish someone, like we talked about in week 1, for doing something negligently as much as we would want to punish somebody for doing something purposefully, right? So how do we decide which level of mens rea, which level of criminal intent to apply to the elements of a crime? Well, courts often look at the intention of the legislature. And a lot of the times when you look at a statute or a law, it is going to tell you what the level of mens rea is. We're going to see that later on in the chapter as well. Okay, so we see the first case to try to see a court apply mens rea. So the facts of this one, a sailor way back in the 1870s goes into the bulkhead of what I can only imagine is a old-time wooden cargo ship. I think of a pirate ship. The whole time I read this case, I'm thinking of Pirates of the Caribbean. Captain Jack Sparrow goes down into the bulkhead to steal some rum, drills a hole in the rum cask, tries to fill the hole after he's taken his fill of rum, and he was using a match, presumably to see what was going on down there, and he got that match too close to the rum. And of course, rum, liquor, flammable. The whole thing goes up on fire, and he completely burns the ship. The prosecution in this case, which is, what did they call it? The Court of the Crown. The Court of the Crown was trying to decide the issue. If a person is engaged in a felony and is trying to conceal the fact that they're engaged in a felony and does some collateral act that would be a felony if done intentionally, is he guilty of the latter felony? So let me try to make that make more sense. If Captain Jack Sparrow is committing a felony by stealing rum, and he commits any felony, any other felony, while he's doing that, in this case, burning down an entire ship, is he guilty of burning down the entire ship, even if he didn't try to or didn't want to? The answer is no. The answer is no. And that's what the prosecution was saying. Let me backtrack a little bit. The prosecution was saying that because he accidentally burned down the ship while he was committing the felony of theft in this case, then he should also be guilty of the felony of burning down the ship, even if it was an accident. The court said, no, we cannot stretch it that far. The act must be intentional and willful. The intention and will can be proved by the fact that the defendant knew the injury would be the probable result of that act, but disregarded the potential consequences. So here, there was no evidence that good old Captain Jack Sparrow knew that he was going to burn down the whole ship. He did not strike that match with the intent to burn down the ship, and there was no evidence that he knew that that was a possibility. Now, is it dumb? Yes, absolutely. But there was no evidence before the court to show that he knew that that was a possibility. And of course, as we now know, courts can only look at the facts and the evidence before them. So since there was no evidence to the jury that the defendant, Captain Jack Sparrow in this case, acted in disregard to consequences that he knew existed, then he can't be convicted of that. His indictment is quashed because he did not have the requisite mens rea. He did not have the criminal intent to burn the entire ship down. It was simply a collateral act of the theft of rum, but it was a collateral act that there's no evidence he knew would result in the burning of the ship. All right, so it's important to note that you need to have, to some degree, whether it be the lowest or the highest, you need to have the requisite mens rea proven beyond a reasonable doubt for you to be guilty of the crime alleged. Okay, and you'll see on page 51 there is a side note. You'll see in the gray box there, if any of you have seen Legally Blonde, but that is attached here, which I am absolutely going to make you guys watch here if it works. Lucky for you, it doesn't seem to be working. So you'll have to watch that on your own. But it is saying that malum in se, and this is just a side note, this does not necessarily have to do with mens rea, but it's in here, so I want to point it out. Malum in se is a crime or an act that is inherently immoral. Think your murders, your arsons, where you try to burn something down maliciously, your rapes, of course, that is inherently immoral. That's something that society looks at as completely taboo, not something that a civilized person does, not something that should ever, ever, ever be condoned on. Okay. Now, on the other side of that, you have malum prohibitum. That is a regulatory infraction. Think you're speeding, so you're failing to stop at a stop sign, those type of things. Not something that is inherently immoral, but something that the legislature has nonetheless attempted to regulate because it can be construed as bad. Okay, so not necessarily a big deal for us in this chapter, but just something that I wanted to point out because it's in there, and if you guys read it, I didn't want you to be confused by it. So that brings us to the definitions of the model penal code mens rea terms. So like we talked about, purpose. They act purposefully with respect to a material element of an offense. When? Number one, if the element involves the nature of his conduct or as a result thereof, it is his conscious object, to engage in conduct of that nature or to cause such a result. And if the element involves the attendant circumstances, he is aware of the existence of such circumstances, or he believes or hopes that they exist. That is a lot of words to say that I intend to do something in the circumstances which I see before me. Okay, so in real life, if somebody intentionally points a loaded gun at someone's head, they know the gun is loaded, and they pull the trigger, they intended to kill that person. Absolutely. That is purpose. That is something where all the circumstances are there, aware of the circumstances, and they intend to do that thing. So I know it's a lot of words for that, but purpose is actually one of the easier ones to grasp. It is what it is. You are trying to do something, and you know what you are trying to do is going to cause a certain result. Knowing, a little bit trickier, and I'll explain knowing like I do and like a lot of attorneys do when we're picking a jury, when we have to explain what knowing is to a jury. So a person acts knowingly with respect to a material element of an offense when, number one, if the element involves the nature of his conduct or the attendant circumstances, he is aware that his conduct is of that nature or that such circumstances existed. And two, if the element involves a result of his conduct, he is aware that it is practically certain that his conduct will cause such a result. Again, a lot of words for not too difficult of a concept. In real life, if we are actually in person in class and you are all sitting before me in that tight classroom, tight quarters, if I take my pen out of my briefcase and I throw it into a crowded class, let's say all of you showed up, everybody was present, you're almost shoulder to shoulder, I'm practically certain a pen is going to hit one of you. I know the circumstances of the class. What are they? That it's a tight classroom, it's shoulder to shoulder. I know that, I see that in front of me. I throw the pen, it's going through the air. I know that it's very, very likely that it's going to hit one of you. Did I intend to hit one of you? Maybe not. Maybe I threw it in frustration because my PowerPoint wouldn't work. But I know that it is practically certain that it's going to hit one of you. That's knowingly, okay? Even if I didn't intend, even if it wasn't my purpose to hurt one of you. So hopefully that you can see the difference between doing something purposefully and doing something knowingly. Recklessly, that is one that we kind of already discussed when this was brought up. Now, the exact definition is that a person acts recklessly with respect to a material element of an offense when he consciously disregards a substantial and unjustifiable risk that the material element exists or will result from his conduct. Now, the risk must be of such a nature and degree that, considering the nature and purpose of the actor's conduct and the circumstances known to him, its disregard involves a gross deviation from the standard of conduct that a law-abiding citizen would observe in the actor's situation. So, in real life, if I go 50 miles an hour through Schreiner University campus, even when I think that the students are gone for spring break and I hit a pedestrian, yeah, you bet I'm liable for that. It's reckless to go through a crowded college campus at 50 miles an hour. That's why they have all those speed limit signs. So it is reckless to do that. A law-abiding citizen, one of normal character, would not do that. It is reckless to do that. And that separates us from negligently just a little bit, and you'll see here in the example. So it's negligent, not reckless, but negligent with respect to a material element of an offense when he should be aware of a substantial and unjustifiable risk that the material element exists or will result from his conduct. Now, the risk must be of such a nature and degree that the actor's failure to perceive it, considering the nature and purpose of his conduct and the circumstances known to him, involves a gross deviation from the standard of care that a reasonable person would observe in the actor's situation. So, of course, we just had that very long drought here in Central Texas. In real life, if I have a bonfire in a fire pit during a time in which it was obvious that the conditions were hazardous, that's criminal negligence. If I should have known that there was a burn ban, if I should have known that it's hot out, that it hasn't rained in months, that it's dry, the grass is yellow, it is negligent of me to have a bonfire in my backyard. Okay, that's the standard of care that a reasonable person would observe. A reasonable person would look at all those considerations. They would call the fire department, see if there's a burn ban. They would do all those things, and then they would ultimately decide it's not a good idea to have a bonfire. So I would be criminally negligent if I ignored all that and I had a bonfire anyway. Is having a bonfire hazardous in and of itself, like speeding 50 miles an hour through a campus is? No, not always. Not always. Speeding through a campus at 50 miles an hour is almost always reckless because you can assume that even if it's spring break, there's going to be people there. There's going to be tight bends. There's going to be security guys in golf carts. That's reckless to do that. Since it's not always a hazardous idea to have a bonfire, it can be negligent if the conditions persist and the conditions show that it's an awful idea to have a bonfire. Then that's negligent. And I hope that kind of clears up the difference between those two aspects or those two terms of mens rea, at least as it deals with the model. So is it the same mens rea for each element of an offense? The answer to that question is yes, unless otherwise provided for in the law or unless a contrary purpose plainly appears. So what that means is if a law defining an offense says that the offense is committed if somebody acts knowingly, then knowingly applies to every material element unless the law makes sure to distinguish different mens rea for different elements. And it's important to note that the model penal code terms go in order. So if recklessness is enough to establish an element of an offense, then so is negligently, knowingly, and purposefully. If it is reckless for me to start a, well, let's see, if it's reckless of me to injure somebody with my vehicle, then it's certainly enough if the prosecution shows I did it purposefully. Absolutely. If knowingly is enough to establish an element, then purposefully can also do that. If I knowingly assault someone, then purposefully, of course, if I really try to assault that person, that suffices. However, if the law says that the mens rea for assault has to be knowingly, then it's not enough if I did it recklessly. Okay? They go in order. They don't all interchange. They interchange up. Okay? So, since the terms go in order, so does the degree of the offense sometimes. That's what we talked about a little bit earlier when we first started the lecture, is that we want to punish people more generally if they have a higher level of criminal intent. We want to punish somebody that purposefully assaults someone more than we want to punish somebody that is simply negligent or reckless. And you see that in Texas as well. You see that almost everywhere. So in Texas, a real life example is in section 22.04 of the Texas Penal Code. You'll find that the section of that penal code deals with injury to a child, elderly individual, or disabled individual in Texas. I actually had a mother of a client call me today and say, what is my daughter charged with? What, I don't get it. I don't know what the charge is. And I said, well, she's charged with a felony of injury to a child, elderly individual, or disabled individual. I don't know which one it is yet because I don't have the evidence. And she goes, well, I called the cops. And I was like, okay, well, was it against you? And she goes, yes, but I'm not a child and I'm not disabled. I was like, well, ma'am, how old are you? 75. I'm like, okay, that means elderly. Okay, so it was you. You were the complaining witness there. But the reason that this is a good example is that it is a lesser felony under this section if the actor commits this offense with recklessness or criminal negligence. And you'll see that in subsection E and subsection G. Okay? It is a lower felony. You'll see very clearly in E that it's a first-degree felony when it's committed intentionally or knowingly, but only a second degree if it's committed recklessly. Under subsection G, it's a state jail felony, which in Texas is the lowest level of felony, when the person acts with criminal negligence. And we've already answered the question of why, because if somebody is simply negligent, we don't want to punish them as much as we want to punish the person that purposefully injured a child, elderly individual, or disabled individual. I hope that makes sense to y'all. I think that's a fairly easy concept to grasp there, of course. It ties back into week one of why we have punishment and what the general theories of punishment are. So I want to address briefly intent versus motive. All right, that is important, I think, to address because a lot of people get very confused in real life when we have a trial and they say, well, I didn't see any motive. It just doesn't make sense that he would do that. Now, that works out for me as a defense attorney because I get to say, yeah, there's no motive. None of it makes sense. None of it makes sense. Well, guess what? The prosecution does not have to prove motive. Okay, not in Texas, and I'm pretty sure not anywhere. You don't have to prove motive. Why? Because intent focuses on the mental state of the offender. And that is what's critical to criminal liability. What was the desired result of the defendant's actions, right? That's the intent. Now, it's a little bit confusing because obviously there's a desired result when somebody acts purposefully. And you could say that there's a desired result when somebody acts knowingly. But how can you say that there's a desired result when somebody acts recklessly or with criminal negligence? Well, the desired result is one that we are inferring based upon their actions, that they should know what the result should be so we can call it almost a desired result, right? Motive is the reason that the offender committed the offense. And the reason I put in this slideshow, if any, again, is sometimes there isn't a motive. And that's a tough thing for juries to grasp sometimes, is that sometimes people just do criminal stuff and sometimes there's not a clear motive. But the general question is, why did the offender commit the offense? And like I said, that does not need to be proven in a criminal case. Now, the reason that it is still discussed and still not critical, of course, like we said, it's not critical, but it is often a topic of discussion, is because it can be considered by a prosecutor when they are offering a plea deal. If somebody intended to steal, they intended to take bread from a store, what was the motive? If it was the motive that their children were starving, they just got fired from work through no fault of their own, she's a mother at the end of her rope, then of course that plea offer is going to be substantially lower than somebody that steals just to steal. Okay? In the same vein, it can be considered by a judge when sentencing someone, right? Same example there. Okay? Is that, of course, the judge is going to get a lighter sentence to the woman stealing bread for her children rather than some white collar guy on Wall Street stealing out of pure greed. Those are going to be different. All right. Motive absolutely affects sentencing sometimes, but it does not need to be proven. Okay. Justice Alito sums it up pretty well in his concurrence at the top of page 57. He says, if person A puts a loaded pistol to person B's temple and shoots person B through the head deliberately, it is obvious that in every such case, the intention of person A must be to kill person B. However, it throws no light whatsoever on person A's motives for killing person B. Could it have been a desire for revenge? Could it have been a desire for plunder? Or was it self-defense? You can't tell motive through intent. All right. So 57, there are another set of examples just below Justice Alito's differentiation of those two concepts that I think make it really clear there for y'all if you have any more questions on intent versus motive. So right now we're going to take a quick break, take 10 minutes, stretch your legs, go to the bathroom, whatever y'all need to do, okay? Okay, and we're back. We're about a little under halfway through this. So chugging along here with the hypothetical number 1, which you can find on page 57. This is a very tragic hypothetical, as most of these have been so far, but it is addressed in the real-life case of State v. Garcia Cisneros. And you'll find in this hypothetical, which unfortunately was true, is that a defendant ran over a pile of leaves for fun, felt a bump, and she tragically had ran over 2 young girls playing in the leaves. She did not know it until after she got home. What had happened in real life is that her brother had gone down the street on his bike. He saw a man screaming and two little girls, and went back and told the defendant, who thought he was kidding. And when reality set in, she was obviously distraught at what had happened. The hypothetical asks, did she act purposely, knowingly, recklessly, or negligently? Now, you'll find in the actual case, the defendant was not charged with manslaughter or murder. She was charged with not remaining at the scene of an accident. The court held that the statute required her to stay only if she knowingly was involved in an accident. So they found that she did not commit that offense. She did not commit the offense of not remaining at the scene of an accident because she didn't know that she was in an accident. Now, back to the question of the hypothetical. Did she act purposely, knowingly, recklessly, or negligently? It's a tough one. Is it negligent to run your car through a leaf pile? Is it outside the norm of reasonable caution? You could argue that it is, I think, maybe, but you could also very well argue that it's not. So what do? We read the case and we know that she wasn't charged with murder or manslaughter. And what does that tell us? That tells us that the prosecution thought that they couldn't reach that level. They couldn't reach whatever mens rea it takes in that case, in whatever jurisdiction they were in. They couldn't reach the requisite mens rea for manslaughter or murder. Okay, so that tells us probably not. She probably did not act purposely, knowingly, recklessly, or negligently. How many times have you run your car through a big puddle? You know, how many times have anyone here run their car through a pile of leaves? You know, it's not what you expect for somebody to be in there, of course. They didn't see any girls running around that we know of. They didn't see any girls playing in the leaves. I mean, there was nothing to indicate that what they were doing was negligent, right? Even the lowest level. Because if we go back to the hypothetical that I gave earlier, it's negligent for me to have a bonfire when I see all the warning signs of a bonfire being a bad idea. If we look at this hypothetical and if we read the case, are there any warning signs? Are there any things? Am I aware of any circumstances that would make what I'm doing negligent? Doesn't seem evident in this case, and it doesn't seem evident in real life where they didn't charge her with any of those more serious crimes. So the answer, like you'll find in a lot of law, is it depends, but probably no, she did not act purposely, knowingly, recklessly, or negligently. Going to hypothetical 2. What happens if a defendant is charged with possessing child pornography and that defendant says that he thought the images were virtual and not real? We have to look at the mens rea, right? It's addressed in State v. Vadine. And again, this is going to be on page 58 for y'all. Now, if you read that case for itself, the court does not address this exact question. But if you read the opinion, it seems to suggest that if a jury believed the defendant, then he could be acquitted. Okay? So if he did not know that the images were real, if he did not purposely possess real images of children, does he have the requisite mens rea? Maybe. But I want you guys to think too, if you were the prosecutor, wouldn't you argue, if you could, of course, You would have to look at the statute and find out. But couldn't you argue that it was at least negligent to have pictures of real children instead of virtual images? Wouldn't have been negligent if they were that close to look at those and have those on your computer? I think a prosecutor could very well argue that if it was allowed by the statute. Because remember, oftentimes the statute provides the mens rea. Oftentimes the statute will make it a crime to knowingly possess child pornography. It's very possible the statute doesn't say recklessly or negligently. Sometimes the prosecutor has to reach the burden provided in the statute, the level of mens rea that is in the wording of the law. Okay, so it would be worth looking into to see if a prosecutor could charge somebody with negligently having pictures, because then I think you could very well get there. You could say that it's negligent to have real pictures when you thought they were virtual pictures. I think that's certainly a possibility. Moving right along, I want to address strict liability for just a second here. It is a little bit of a tough concept because we've just gone over 4 levels of mens rea, starting from negligently up to purposely. But with strict liability, is there a requirement for mens rea? Not necessarily. And it's a very, very narrow section here. Very narrow laws that this applies to. Speeding, failing to stop at a stop sign, statutory rape. Those are things that are just strict liability. There's no excuse, you can't do it. Speeding, I don't have to negligently speed. I don't have to purposely speed. As long as my car was going faster than the speed limit, I can get tagged for speeding. I can absolutely have to pay a ticket for speeding. Okay, that's just how it is on some of these cases. Now you'll see in the United States, that is exactly what they tried to pin on this defendant. The defendant had an AR-15, which is normally a semi-automatic rifle, popular in the United States, of course, that was modified to be fully automatic. So to make this weapon go from semi-automatic to fully automatic, several steps have to be done. And you'll see that in the opinion given by Justice Thomas in here. Fully automatic weapons, of course, have to be registered. All right, so he was indicted for possessing an unregistered, fully automatic weapon. Now, the defendant claimed that he did not know the AR-15 was modified to fully automatic. He had never shot it fully automatic. He didn't know you could. He thought it was just your everyday run-of-the-mill AR-15. So how was he supposed to know that it was fully automatic? He had no idea. There was no clue there for him. The trial court did not instruct the jury that they had to find beyond a reasonable doubt that he knew the gun would fire fully automatically. The trial court said, no, I don't care that you didn't know. That I want this to be, or I think it is, one of those strict liability things where all that has to be proven beyond a reasonable doubt is that you intended to possess this gun, not that you knew it was fully automatic or could fire fully automatically. So we talked about, how do we know what the mens rea is? Well, you look at the law. Well, here's the issue in this case. The legislature was silent regarding the mens rea. They didn't say what it was. They didn't say if it was knowingly or purposely or recklessly or negligently. That wasn't in there. So since the legislature was silent regarding the mens rea for this law, does the jury have to find that the defendant knew the rifle could fire fully automatically? That's a tough question to answer, but the court says yes. The court says yes, they did have to find that. They should have been instructed on that. The government should have been required to prove that the defendant knew his rifle could shoot automatically. So how did they apply this? They came to this ruling. How did they apply that to the facts? They said if the legislature had intended to make outlaws of gun owners who were wholly ignorant of the offending characteristics of their weapons, the legislature would have spoken more clearly to that effect. And they cite a couple of cases primarily in here, which we will get to in a second. They cite the first one, which is Morissette, which we will speak about here, and another one, which is Bolint. They reasoned that guns are not inherently dangerous like grenades and deadly narcotics, so there is no strict liability. Okay? Now, of course, that's the application. It's the United States. There's millions and millions and millions of gun owners, of course. It's ingrained in our culture. It is ingrained in our Constitution. It is our Second Amendment. So guns are not inherently dangerous, the court finds. So there is no strict liability. So the prosecution had to show that the defendant knew that his gun was essentially more dangerous than any other gun, that it could shoot fully automatically. So the case is reversed so that the government must prove that the defendant knew that his rifle fired fully automatically. Reversed back for a new trial so that the trial court could give that proper instruction. So another way to say it here, you'll find on page 61 in the second paragraph, is that we have reasoned that as long as a defendant knows that he is dealing with a dangerous device of a character that places him in responsible relation to a public danger, he should be alerted to the probability of strict regulation. They say that doesn't apply here. It applies with things like opioids and hand grenades, but not to firearms because they are so common and they're not inherently dangerous in that manner. All right. So here are the two cases that are referenced heavily in the case that we just discussed, which is Staples. Go and look at page 67 and you can see a detailed facts of each case. So if we look first at Morissette, this case is dealing with a guy that goes deer hunting in a sparsely populated part of Michigan. The issue is that the United States government was using that sparsely populated part of Michigan as essentially a firing range for simulated bombs. So these bombs were fake bombs just to basically do target practice. And once they were used, they would throw away these metal canisters. Essentially, they would pile them up in heaps, no fences around them, no nothing, just laying out in the elements to rot. They didn't care for them at all. There was no intent to keep them, it seemed like. So what did Morissette do? Morissette couldn't find any deer, so he said, shoot, I need to do something productive with my time. And he took quite a few of these cylinders. I want to say it was about 3 tons. Yeah, 3 tons of them in his truck and took it to a nearby farm. He flattened them out and he sold them. He sold the scrap metal, basically. For 84 whole dollars, he sold that scrap metal for. And what did the U.S. government do? The U.S. government said, hey, you can't do that. That's our trash. And they prosecuted him for stealing it. And if you read the case itself, rather than just the facts here you have on page 67, he tells everything right away. He's an outstanding citizen. He's never been in trouble before. He was an honorably discharged veteran of World War II. He told him right away, he goes, my bad, fellas, I thought it was trash. I didn't know. I just didn't know. It seemed ridiculous that this wasn't trash. He told everything. He got on the stand. He told the jury, and yet was still found guilty of this theft. And so he brings it all the way up to the United States Supreme Court. He wants to, of course, protect his clean record. He's not a thief. You know, don't call Morissette a liar or a thief, because he'll take you to the Supreme Court. And the Supreme Court agrees with him. Absolutely. There is a shred of common sense left in our court system. They said that the jury was not properly instructed. There we go again with the failure to properly instruct the jury. The court said that, yes, you have to tell the jury that Morissette could only be found guilty if he intended to deprive the government of the property. Well, there's no deprivation of the property if he thought it was trash, right? Where's the mens rea there? He didn't intend to take something that he thought the government was using. There was no sign that the government was using any of this. It was just laying there rusting away. Okay? So they reverse it. They say, no, he's not convicted of that. That just doesn't make a lick of sense. Now, let's go to Balint. And the facts of this case you see are at the bottom of page 67, going into page 68. This is where we get into more of a strict liability, because Balint was dealing with deadly narcotics, right? An opium-based substance. Since they are inherently dangerous, and the defendant's conviction was affirmed, even though he denied he knew its contents. He admitted he sold an opium-based substance. He said, yeah, I sold that. But he said, I didn't know that it was, in essence, an opioid, that dangerous. Strict liability for this. Strict liability. They're saying that this is just such a dangerous item to have that you should know better from the get-go. You shouldn't have to ask twice. You shouldn't have to look at anything. You should know that you shouldn't be selling this type of item. You shouldn't have it. It's that dangerous. Okay? So it is a bit of a difficult concept to grasp, If you see it in real life, you just have to ask yourself, is this so dangerous that mens rea may not even be required? Okay? And that is usually going to deal with things like items, things like that. Okay? Now that brings us to our intoxication and drugged conditions. In general, voluntary intoxication is not going to be a defense to a criminal charge. Courts have been extremely reluctant to acquit defendants due to voluntary intoxication. And the reasoning for that is pretty simple. It is because being intoxicated obviously affects one's decision making. The courts say it themselves here, is that just in general, people that are intoxicated make worse decisions and can still absolutely form criminal intent. Just because you're a little more bold and a little more brazen doesn't mean that you're not doing something without the requisite criminal intent. Okay? Now, they go on to say that it also has to deal with what type of intent. So, intoxication or a drugged condition can negate the mens rea for a specific intent crime, but not a general intent crime. And that brings us to People v. Atkins, where they try to make that difficult differentiation for us and illustrate what exactly that means. So we look at this case. We see that the defendant made it known that he did not like Orville figs. He hated Orville figs. We see later in this case, it appears that he has that animosity toward Orville figs because Orville figs now owns the land that the defendant's family used to own. So there is, of course, some animosity there. The day after he made it known that he hated Orville figs, the defendant and his brother drove onto that property, and they were there for a few hours. And what happens? Somebody sees them leaving, right before they see a big fire starting to spread. Okay, so the fire burns for over 3 days. It covers between 2.5 and 2.8 miles. It got very close to Figgs's house, and they go in and they investigate it. And the fire marshal somehow in 2.8 miles or 2.5 miles, somewhere in that range, traces it back to an area and discovers where it originated. It was discovered that it originated with chainsaw mix, which is just a combination of gasoline and oil, obviously flammable. And of course, what is miraculously right next to it but the defendant's wallet? And what was also found was a recently opened beer cans, a lighter, and several more beer cans. So cops go and they talk to defendant. Defendant says, I was drinking all day with my brother, drank some more once we got to the part of the land where the fire started. And I pulled out some weeds, I placed them in a small pile, and I lit it on fire after covering it in chainsaw mix to just, get rid of the weeds. And it quickly got out of control. They said they tried to put the fire out unsuccessfully, and they fled while everything was still burning. Claimed the fire was an accident. Well, then what? The issue becomes, does arson require specific intent, or does it require general intent? The court finds that arson requires general intent. Thus, the client or the defendant could not claim that his voluntary intoxication negated the required mens rea. So, if you look at the bottom of page 71, you see them attempt to differentiate between specific and general intent. They say when the definition of a crime consists of only the description of a particular act without reference to intent to do a further act or achieve a future consequence, we ask whether the defendant intended to do the prescribed act. This intention is deemed to be a general criminal intent. So what's the general intent here? The general intent was to set fire. The specific intent would have been to set fire with the purpose of achieving the act of burning down Orville Figgs's house. The court said no, it was just general intent to start the fire. And if it's just general intent, voluntary intoxication cannot negate the mens rea. Okay? So how did they decide that arson was just general intent? They said that there's no language to create specific intent. They said that language that typically denotes the legislature's intent to create specific intent crimes was lacking. And you'll see that in statutes. Statutes that have or that denote specific intent often have that in there, with language such as with the intent to achieve or for the purpose of achieving some further act. They don't have that here, so they find it is general intent. The conclusion is that the Court of Appeals erred by finding that arson is a specific intent crime. Because what happened? The trial court said it's general intent. The intermediate court said it's specific intent, but the Supreme Court here in California, the Supreme Court says no, it is general intent. So the intermediate Court of Appeals got it wrong by finding that arson is specific intent. It is a general intent crime, and evidence of voluntary intoxication does not negate the required mens rea. So the big rule here being, the rule that y'all have to remember, is that if it is a general intent crime, voluntary intoxication does not help you. If it is a specific intent crime, then voluntary intoxication might help you, or at least you can put on evidence of it. Okay? Now, that brings us to mistake of fact. Mistake of fact is only a defense to a crime of criminal intent. Okay? So, for example, it's not going to be a defense if it's a strict liability crime. All right? Only a crime, or only a defense to a crime of criminal intent, or scienter is that word up there, only where the mistake precludes the existence of the mental state necessary to commit the crime. All right? So the mistake that you make, it doesn't work if it simply makes you guilty of a different crime. So here's an example of where it would be a valid defense. I go to sell one of y'all baking powder. You ran out. You text me. You say, Professor Cleveland, I'll give you $5 if you bring me a bag of baking powder to class today. And I say, okay, yeah, that sounds like a great deal. However, unbeknownst to me, a drug cartel has smuggled cocaine into the country in a normal looking box of baking powder. If I give you that box of what I think very well and with good reason is baking powder and not cocaine, then I'm not guilty of delivering a controlled substance to you because I genuinely thought I was selling you baking powder. All right. So you will see a example in Iowa v. Freeman here. Here, the mistake of fact defense did not work, and we're going to get into why. Here, the defendant went to sell actual cocaine to someone. However, that person was a snitch. That person was a confidential informant. They were working with law enforcement. It was a controlled buy. The informant paid $200 for 2 grams of cocaine, but it actually ended up being acetaminophen. But the defendant thought that he was actually selling cocaine. Now, in real life, that is pretty hilarious that the big bad drug dealer mixed up his cocaine and his acetaminophen. That's just pretty funny to me. But the defendant is charged with delivering a simulated controlled substance. So he's charged essentially with delivering fake cocaine. So still a crime in Iowa, clearly. But the issue is, can the defendant be convicted of delivering a simulated controlled substance when he believed he was delivering and intended to deliver an actual controlled substance? The court says, yes, absolutely, get out of here with that. A person who delivers a substance that they believe to be a controlled substance commits the offense of delivery of a simulated controlled substance. Well, why is that? Because in this case, the defendant would not be innocent of any wrongdoing had the situation been as he supposed, right? So if what he thought was happening, he thought he was selling cocaine. If that was true and it turned out to be cocaine and not acetaminophen, he'd still be guilty. He would just be guilty of delivering an actual controlled substance. So the mistake of fact doesn't preclude criminal intent, right? Because he intended to do something wrong, something crazy wrong. You can't sell cocaine. You can't sell drugs. The government and the law frowns upon that. So the court says it's the mistake of the fact here is not a valid defense because he still had criminal intent. He still had the intent to sell cocaine. So I hope that is plenty clear to y'all. Look here. That brings us to hypothetical number 3. We have our homicidal clown. This is on page 76. If you read this, it asks, as part of a circus act, a clown is supposed to point a gun loaded with blanks at another clown and pull the trigger. One day, unbeknownst to the clown who pulled the trigger, the gun was loaded with real bullets. When he pulled the trigger, he shot and killed the other clown. Does the clown have a good defense to potential homicide charges, and why? Well, ladies and gentlemen, we saw this just last year, in the last 12 to 18 months or so. Alec Baldwin did exactly this, at least on the surface level, we don't know everything yet, but on the surface level, this is essentially what happened. He shot a gun that should have been loaded with blanks at somebody and he killed them. Now, does he have a good defense? I think so. I think so. Did he have the mens rea to cause the death? I think that is the important aspect of this here. Because what is murder? Murder is a specific intent crime. You act with the intent to cause a death. So there's no doubt that he acted. He purposely acted. He purposely acted to pull the trigger. But did he have the requisite mens rea to cause a death? No, he did not. That's the defense. That is saying he did not purposely, knowingly, recklessly, or negligently intend to cause a death. Now, that's homicide, right? What if we go to manslaughter? Manslaughter, maybe, because then what do you have to show? You have to show recklessness usually. So was it reckless to not check and see if the bullets were live or if they were blanks? Could be argued. Could be argued. But let's think back to Staples. There's no strict liability because it's not inherently dangerous, right? You need a mens rea for this, 100%. These, there's nothing inherently dangerous here about a circus act with what is supposedly a fake gun or blanks in the firearm. All right. So obviously not strict liability. So we need to have some mens rea. It's not here for homicide. This clown did not intend to cause the death of the other clown. Going to hypothetical number 4, the old he looked 18 defense. Ladies and gentlemen, this is well settled case law. Pretty much everywhere. Okay, I'd be shocked if one of you found a place where this is not settled case law. He or she told me that she was 18. It just doesn't work. Here we absolutely have strict liability. There's just almost no defense. Okay, even if a 13-year-old tells an adult that they're 18, that person's still guilty of sexual assault of a child. Mistake of fact is not a valid defense here. And it's strict liability because it's so serious, of course, sexual crimes with children. That the legislature has basically said, and the courts have backed them up, saying there's no required mens rea here. It's strict liability. You can't do it. All right. So it's not a valid defense to these charges in hypothetical number 4. Okay, sorry about that. I think that was one of our recording mistakes here. Hopefully it worked out just fine. But you'll see a big fat bold and at the end of number 3 here under the elements of mistake of law. That means that all 4 of these have to be met. So if you look at these, number 1 is that they erroneously conclude in good faith that whatever they're doing, whatever their conduct is not subject to operation of criminal law. Number 2, they make a real diligent effort adopting a course and resorting to sources and means at least as appropriate as any afforded under our legal system to ascertain and abide by the law. Number 3, they act in good faith reliance upon the results of such effort that you find under number 2. And number 4, whatever they did that constitutes an offense is not immoral or antisocial. And that is exactly what we see in Kipp v. Delaware. So in Kipp v. Delaware, we're looking at the facts of this case. There's a man with a gun complaint by the defendant's girlfriend. They go, they check it out, they find the defendant in his home, and then they find 3 guns with him. And while they find these guns, they run his background, and sure enough, they see that he was convicted of an offense that typically destroys a person's rights to possess firearms. So they charge him with unlawfully possessing those guns because of his criminal record. Now, the defendant's defense is he wasn't aware he could not possess guns. Typically, that defense isn't going to work. However, they go back and they look, and on the face of the judgment of his guilty plea of that old charge that they found, it says not applicable, or NA, in the box determining if he's prohibited from possessing guns. So they go, okay, well, I mean, shoot, he's right there. It doesn't say he's not supposed to possess guns. So they go and pull the record from the guilty plea, and the record shows that neither the prosecutor or the judge addressed this at his guilty plea for his old charge. So does the defendant have a valid mistake of law defense? The court says yes, and funnily enough, the prosecution says yes too. They concede it on appeal. They say, yeah, that's not fair. This is a true mistake of law defense. It is appropriately recognized where the defendant demonstrates that he has been misled by information from the state. And that's what happened here. His guilty plea document on his old charge was never corrected by either the prosecutor or the judge. So if the state is telling you that your charge is not applicable to whether or not you can possess guns, and then you say, okay, and you possess guns, the state can't turn around and say, gotcha, you're going to prison, right? That would be inherently unfair. So that is a bona fide mistake of law. So he could not then form the mens rea necessary for culpability because he didn't know. He didn't knowingly possess a gun that he knew he wasn't supposed to, right? So there's no mens rea here. And that's why his conviction is reversed and his mistake of law defense is valid. Okay, so for next week, we already talked about the discussion posts, and hopefully this clarifies any confusion going forward. Every week from now on, it should be fixed. 2 replies are due by 11:59 on Sunday. So for this week, that is Sunday, February 4th. Your initial post is due on 5 p.m. on Thursdays. So by the time you watch this, you should have already done your initial post for the discussion question for the week. Now, also importantly, we have quiz number 1. It is live and it is due by Friday, February 2nd at 8 p.m. It's 25 questions if you haven't done it yet. It is a mix of multiple choice and true false. Each question is worth 4 points. That thing is going to shut down at 8 p.m. on Friday. So make sure you start that thing by 7:30, okay? Because it is due at 8 p.m. So start it no later than 7:30. Also due coming up soon is the current event article number 1. That is going to be due by 11:59 p.m. on February 8th, okay? That is a Thursday, and let me double check it. I'm not giving you guys any more wrong info. February 8th, that is Thursday, next Thursday, all right, by midnight. And those instructions are in the syllabus, okay? Also, read Chapter 4 for next week and watch the Michelle Carter videos in Module 2. The Michelle Carter videos, if you guys have not heard about that case, it is a highly interesting case. It is one of the most fascinating looks into mens rea that has probably occurred in the modern era of law, especially with the advance of technology and texting and everything like that. So go watch those videos. We'll talk about them next week. Incredibly interesting case. As always, if you guys have any questions, please feel free to email me. I will get back to you as soon as I can. I will be out of town until Monday, February 5th. Okay. So I will look at my email on Monday, February 5th. I will answer everything as soon as I possibly can. So have a safe weekend, and we'll see you guys next week in person again. Thank you.